bec because here is no sanction. No explicit sanction was given by the chairman and the managing director. Also, my lord, in a slipshod manner, they have done it because my
Where is the order of punishment? Let us see.
my lord, the conviction or the punishment order, my lord, by the
No, the authorities have passed an order depriving you of all your pensionary benefits.
yes,
Where
my
is
lord.
that order?
Yes, my lord, kindly takes page 78, my lord. 77. It starts from 77, my lord.
My lord, I am appealing on behalf of the PSN. Convicted. Convicted.
That means, you see, pension was not paid to you after your retirement due to this case, pendency of this
Provisional pension was there, my lord.
Provisional pension.
Provisional pension was there. It was the clearance from the vigilance was withheld because of the pendency of the criminal proceeding, my lord.
Yes.
And my lord, in the backdrop, my lord, I was a employee of Department of Telecommunication.
Where is Rule 40? Show us Rule 40.
Yes, my lord. My lord, kindly takes page 124.
So there is no question of inquiry. It is in the lines of Proviso A to 311 of the Constitution. On conviction per se, there is no question of inquiry. The conviction itself is a ground for imposition of the penalty.
My lord,
there is no question of any infirmity or any compliance with natural justice.
my lord, natural justice principle, because my lord, of the Rule 61, my lord, kindly takes Rule 61.
The order has been passed under 40, madam.
My lord, also 61. My lord, kindly takes the order once again.
Yes.
Yes, which page?
Where is 61?
Page 61.
What does 61 say?
My lord, Rule 61 says there has to be a sanction.
This is for disciplinary proceeding. There is no question of proceeding when it's based on a conviction. The conviction itself is a ground for your dismissal. They don't propose to hold an inquiry against you. There's no question of any sanction.
My lord, 60. May I read, my lord?
Yes.
Kindly allows me, my lord. The order records Rule 61.
May.
Along with Rule 40, my lord.
That is all right.
Hello,
But see, if they have the substantial power and jurisdiction to pass such an order, that is why initially we looked at the Constitution. The Constitution provides the same. This is prescribed in the BSNL also rules. On similar lines, they have a provision that based on a conviction, you may be dismissed. For that, they need not hold a they don't want a convict to continue in service. It is as simple as that. So they dismissed you. Now there are so many provisions under the rule. Why one should look at the other provisions?
My lord, I was not dismissed for removed
what
from
is the
service.
provision? What is
Rule 40? My lord, Rule 40.
So your case is after your retirement. This
Yes, so there is
started.
no dismissal.
124.
There is no dismissal or removal from service, my lord. In my case, under Rule 40, my lord, I was never dismissed or removed from service. My case, they have with.
How can they dismiss you post
Yes, my lord.
retirement? They cannot.
After cessation of
So
my.
good conduct is a precondition for grant of pensionary benefits.
Yes, my lord. So
now a person who is a convict, can he be considered to be a person having a good conduct for being eligible for grant of pension?
My lord, for grave misconduct, my lord, it is to
You
be.
have to show
Yes,
that these rules are.
Yes,
the
yes, my
rules
lord.
are not
Kindly take
applicable in
61,
your case.
which says for 100%, my lord, withholding of pension. My lord, kindly takes Rule 61 first.
Yes.
Yes, which page?
My lord, it is at page 134, 133, my lord.
133.
Disciplinary provision for retiring employees. My lord,
Yes.
Rule 4.1.
Yes.
Chairman, Managing Director is the competent authority to issue sanction to institute departmental proceeding against an absorbed employee. My lord, I am an absorbed employee. I was firstly with Department of Telecommunication, then I was absorbed to BSNL. After retirement, for withholding of pension for combined service of BSNL and DOT period, herein referred as pension or gratuity or both, either full or in part, or withdrawing a pension in full or in part, whether permanently or for a specified period, and of ordering recovery from pension or gratuity of the whole part or any pecuniary loss caused to the company if any disciplinary or judicial proceeding the petitioner is found guilty. So, my lord, of grave misconduct or negligence during the period of service, including service rendered upon re-employment after retirement, provided that the administrative ministry shall be consulted before any final order are passed, provided further that where a part of pension is withheld or withdrawn, the amount of such pension shall not be reduced below the amount of rupees 1,275. So, my lord, in this,
What was the quantum of punishment awarded to you in Prevention of Corruption Act?
my lord, I was convicted with 4 years penalty, 4 years rigorous imprisonment,
And fine
which has
of?
been suspended,
And-
and fine of rupees 5,000 rupees, which has been stayed by this honorable court.
Okay, fine is stayed and there is a suspension of sentence.
Suspension of sentence. So, my lord, they have withheld in a permanent basis. My lord, kindly takes their show cause notice once.
So that is the question, whether if at all some sympathy can be shown, that part of it that can be withheld.
But
My lord,
That
Kindly-
is not exhausted.
please, let me get a
They are
আচ্ছা ঠিক আছে আপনি দেখাবেন judgment দেখাবেন
What can be withheld? That with the facts of the case.
See this.
Yes, yes,
Yes.
yes, yes. But that should not. So that is the distinction. So this is the very serious cases they can be solved. So if it is a case of part, they can exercise.
What is the conviction? Ask.
It's actually yes, any type of conviction.
Yes.
That does not say that only 24 years. So, punishment is 4 years. They can, whether they can show sympathy that by withholding the part of the conviction. At best, but the court can consider this as well.
Yes, you are appearing
My
for
lord,
the.
may I only indicate one more rule, my lord, kindly allows me.
Yes, yes.
My lord, rule 43, my lord, kindly comes once.
Yes, page.
Page 126, my lord. The DOT employees on absorption in BSNL shall be governed by these rules from date of their absorption in the company date of issue of these rules. However, dismissal, removal from the service of BSNL after absorption for any subsequent misconduct shall not amount to forfeiture of his retirement benefits for service rendered in the central government. So therefore, my lord, as per Rule 40, my lord, as per major penalty could have been given was dismissal removal if I was in service. Now, since I am not in service, my lord, since dismissal removal cannot be given, my lord, my entire pension has been withheld 100% during pendency of the criminal appeal. My lord, also one thing, in the show cause notice, my lord, I was never given a show cause to say that the pension will be forfeited in permanent basis. My lord, if I take you, my lord, allow me to take to the show cause notice.
Yes, where is it?
Yes, my lord.
Yes, which page?
My lord, at page 68.
The BSNL has filed a reply in the tribunal.
Yes.
Before the tribunal,
Yes. We have filed.
You have placed all that on record.
reply they have.
Yes, my lord. We have filed.
No, my lord, that is not placed in my.
Why, madam?
My lord.
and my lord, they did not
My lord,
start
grant
copy upon the
liberty to file it
BSNL.
by supplementary, my lord.
That's a very undesirable state of.
My lord, kindly look into the page 44. The Honorable Justice Nishida Matre has already been decided some point, my lord.
You file a
44.
supplementary,
My
complete
lord,
the
yes, sir.
records
Yes,
And no copy has
and
been
give a
stamped upon the
copy
BSNL.
also. Give a copy to them also.
yes.
Let copies be. You are appearing for the BSNL. Union of India is also a party.
Hey, is another party?
You have been served. And you have not been served.
My lord, we have served on BSNL. Here's the affidavit of service.
Affidavit of service taken on.
কবে ফিক্সড হলো?
September.
From September.
That exam has to be sent.
মানে
Then what? Making it a part. Otherwise, item number 12, the regular bench. If that sympathy can be false,
Question of sympathy.
if that question can be given.
Question is penalty can only be imposed in accordance with the procedure.
Yes.
I don't believe
Whether they are,
the court does not have any power to do.
because the authorities are very powerful.
Yes.
But I appear to the Union of India, the petitioner before your lordship. But service has been, the copy has been served upon the respondent. But not,
Let us see what is the issue.
this is pertaining to stepping up of pay. Stepping up of pay has gone in favor of the respondent by the tribunal.
You serve.
We have served, but not, proceedings it has not affected as yet.
Let service be effected on.
Lordship, item number 13, I am led by Mr. Shobhoshachi Chatterjee. He is engaged in some other court, Lordship. I am praying for not this week.
Last occasion, I'm not opposing last occasion, same prayer.
Why every day you are seeking a Passover or adjournment? You are not interested in doing the matter.
I have been instructed to.
Yes, we remember we had adjourned it. Why again? He is in court, so it should come after 1 week.
Kindly not today, Lordship.
Not today.
My lord, I'm appealing for the petition. My lord, the impugned order is in page 226. Whether it is a
You have not made any mention regarding OA 635 in your OA.
no, we have mentioned it.
Where is it? Show us.
No, my lord, it has not been stated. Matters not previously filed, not OA 65, because that was given liberty to file afresh.
No, sir, that is 338. Come to page 52.
635 of 2022.
Come to page 52.
Yes, ma'am. OA 338 before the Honorable Tribunal, which was allowed to be withdrawn with liberty to file afresh.
Tribunal is referring to OA 635.
Yes, OA 65 was,
Why have you not stated about 635 in your OA?
that was a mistake.
What mistake? That disentitles you to any relief. You are suppressing a relevant material fact from the court. You say about 338, but you don't say about 635 that you have withdrawn it on personal reasons. So for the same thing, you should be allowed to file successive petitions anywhere.
That was a mistake on the part of the.
What mistake? It's a suppression. Have you said that OA 60? What have you said in your writ petition about OA 635? Let us see. You are here under the equitable jurisdiction.
Yes, ma'am.
You have to, your conduct has to be equitable.
Page 6, we have stated in page 6 of the writ petition, my lord.
Page 6.
Page 6,
Yes.
paragraph 16.
Which paragraph? So at the
Paragraph
top.
16, 1-6.
Without any liberty, you have withdrawn. And you have suppressed this fact before the tribunal.
That is a mistake, my lord.
What can be done? I think we cannot encourage such a litigant.
My lord, the fact is that even
Nothing.
after everything, my lord, that
You
that
may have the best of case, but in a writ jurisdiction, equitable jurisdiction, can we allow you to approach us in this way?
my lord, the point of
Not a case of not coming with clean hands. It's a case of suppression of a relevant and material fact in order to gain an advantage. Somehow they have come to know that's a different thing. We cannot
no,
encourage.
my lord, we have expressed that was a mistake. That was not.
We don't know whether it was a mistake or not. You mention about one OA, you don't mention about the other. In one you mention because the earlier OA you had taken a liberty. In the second OA you did not obtain any liberty, so you did not mention. Now whether we are to read a mistake or the circumstances are glaring. It's the only situation. What can be done? No.
My lord, though, my lord, though everything.
We will never encourage such persons. Sorry.
No, my lord. The fact is that this does not come under res judicata.
We are not concerned. We are exercising equitable jurisdiction, our discretionary jurisdiction. Seeing your such conduct, whether we should come to your aid, that is the issue.
That is.
We are not concerned with what you did before the tribunal. Before the tribunal also, if you have exhausted remedies, section 20 is there. You can't say that because CPC does not apply, that does not mean that you can do whatever you want.
No, CPC does apply, my lord. CPC does apply, and that was an inadvertent mistake.
Section 18 is there. You know what is the provision. Sorry.
My lord, kindly look into the matter.
Nothing. The recommendations made in 21, filing a second OA in 22, suppressing the fact in 22. What can be done for you today, sir?
That was not suppressed before the honor.
It was suppressed. There is no disclosure in the OA. It's a gross suppression of a relevant and material fact to gain an advantage. The intention is clear.
When liberty was granted, that is subject to, if he is otherwise entitled to, he can file. Otherwise,
that is a different thing. That was a first round, that is over. He has availed the liberty already. Having availed the liberty, now he is suppressing because this time he did not avail a remedy. We will not come to the aid of such a person in exercise of equitable jurisdiction under Article 226. We will never encourage such a person.
My lord, it's a bona fide mistake, my lord.
Right, then.
15. Appellant is the petitioner before
15
you.
and 16.
The bench. If not the order that is together, the order has the criteria. This one, item 15. If that bench has passed that order, then
Appellant is the petitioner before your lordship. This is an contempt application arising
Which order?
page 25 is page 26.
See whether it is with the same or it is with Justice Tandon.
if that's fine,
Anyway,
then that has to be heard by this.
page
26, my lord. The order from which the contempt application arises.
not today.
Admitted, yes, to be part of the.
He is only in
16.
today, so maybe he will be there too. It's also contempt. Contempt. Can't be taken up by this bench.
Recalling also there.
Huh?
Recalling also there. Your lordship.
But then it can't be taken up by this bench.
I know.
So not today. We'll
Only
keep it.
not. Just now I was discussing with my learned sister. Careful to us. My lord justice বুঝে গেছি ঠিক আছে কাল এসো কাল এসো
Seventeen.
17, I am for the petitioner. There is a direction, my lord. Kindly see, my lord, the order dated 16 June 2023, wherein the Honorable Court, my lord, was pleased to give direction of the Chief Secretary to consider the claim of the petitioner. Now, my lord, this is the order dated 16 June 2023.
Chief Secretary.
Yes,
But there is a high-powered committee.
For Chief Secretary, you are appearing.
no.
I appear for the added respondent.
Tapun Kumar Mukherjee, I'm a senior counsel, appearing for the state. Kindly come to the order dated 16 June 2023.
Where is he? Where is Mr. Mukherjee? 16 January
16 June 2023.
23.
23.
This has not been done.
Nothing. Kindly, your
No
lordship.
development. Lord.
No development.
After your lordship last order, there is no development.
So state
And
authority
now-
who is representing? State authority.
Mr. Tapun Kumar Mukherjee, learned senior counsel.
I was wondering if this we should take.
And kindly, your lordship's order 27 January 2025.
Considered, not yet considered in the stage.
Order dated 27 January 2025 by your lordships.
Why you got this?
27 January.
Let it be taken tomorrow or possible.
They have extended the tenure of the hyper committee, nothing else.
What is it for?
Or just the matter issue is involved, my lord. We are the LDA, LDC of the secretariat.
Now we remember.
Yes.
Mr. Mukherjee had said that he will speak.
But I'm told Lord, he is coming. He is engaged in another court.
Let him, not today. Let
No,
him be.
Lord, your lordship kindly let it be taken up today, Lord. It should, your lordship kindly come back and take up this matter. He is coming. Lord. He is on the way.
Short passover.
When we come back, if he's
but in compliance with your lordship's order dated 21st January, they have filed the affidavit. But in the affidavit, kindly look to the affidavit affirmed by one Dr. Manoj Pant. And kindly come to the last page, which is at page 12, where the life of the hyper committee extended up to 31st July 2025. Page 12.
Have already taken on recording an earlier order.
Pursuant to the order passed by your lordship, report have been submitted on 29th April 2025 to the government. This is in compliance with the court's order. Committee has been constituted. Committee submitted a report to the government, but that document, confidential document, you can produce before the court, but I cannot share with my learned friend.
We attended the hearing, but we have no right to know the fate of the hearing.
Until unless it is accepted.
No, we can't hear you. Can you use the mic?
According to my lord's order, the committee submitted a report on
Yes.
30th April. Now it is lying with the government, but it's a confidential document. But until I can share with the court, there is no difficulty. But I cannot share with my learned friend. If you also wants to see the report, certainly give me some time so that I can produce that entire details report.
No, that report is not binding.
The report until unless is accepted by the government.
Therefore, we are saying it is not binding on the government.
No. It's for the waiting for
When was it submitted? 29/4.
30th April. 29th April. Can you see the letter?
So what is your instruction then?
Report has been submitted to the government. Madam wants to see the report. Certainly I can produce before the court, but I cannot.
No. See, that report by itself will not be of any use unless it is accepted and the terms are notified.
Yes.
Then only it can be said that there is a decision. As of now, you have complied with the court's direction. The high-powered committee has submitted its report. But the fact remains there has to be a decision. So why this inordinate delay in finalizing the thing?
Well, because two groups are fighting each other. One directorate staff, one secretariat staff. That's the number of representatives who are there. They have been heard and they have been given.
But that exercise was over in April.
Now
4 months have passed. Almost 4 months. So this can't be a never-ending exercise.
Well, I will ascertain when it will be.
Tell us, find out.
Yes.
Find out. They are claiming parity with
Scale and restructuring
with which employees?
of secretariat employees, LDC and directorate staff. There are two types of staff, directorate staff and secretariat staff. And they are claiming some financial benefits to each other.
Anyway, some decision ought to have been taken.
Well, I am expecting that the 29th April, 30th April, May, June, more than 3 months passed.
আমরা তো হিয়ারিং অ্যাটেন্ড করেছি, তারপরে রিটেন নোটস দিয়েছি কিছু, তারপরে যাই।
So the hearing was delegated to a committee.
Committee.
Now decision has to be taken by the chief secretary.
In terms of
And-
the order dated 16 June 2023.
And it has been forwarded to the chief secretary. Now it has to be placed before the cabinet. If the government accepts,
11th August 2023, there is a direction, my lord, within 6 weeks. They will
no, we have,
complete the process
process is complete, but just
after
only
2 years.
The authorities that will give him 1 week after reopening to
Application office will be open. Government office will remain open.
Great. Extremely grateful to my lord.
Item number 18.
I'm praying for 1 week adjournment to get some appropriate judgments related to the case, my lord. Praying for 1 week adjournment, my lord.
Victor, appear for the response.
you want a week's time.
But I want 1 week time, my lord, to get appropriate judgments for the case.
As straight list after 1 week. As prayed by the learned counsel for the petitioner.
Nineteen.
Let us.
20. Item 20.
For the respondent, your lordship.
My lord, I am praying for an adjournment as my senior is engaged in another court.
My lord, if it could be fixed, if a date could be given after Wednesday, my lord, if it is possible, my lord.
এর মধ্যে নেই এইটার মধ্যে নয় এই আইটেমে নয় দাদা তো কোটেই নেই আমরা
Where is the file?
আজকে যে ঠাকুর ও আসলে
File hoga na? File hoga na?
আসেনি আজকে
Call the next item.
Item number 21.
আজকে ফাইল নেই অর্ডার কি করে হবে
It's not possible to pass an order if the file is not there.
My lord.
করবে অর্ডার
The last part of the
6th August.
The order impugned before the tribunal?
The earlier, your lordship, earlier order I am giving that. Learned AGP submits.
The order impugned before the tribunal. Where is the order?
Yes.
It's 23/8/23. What is the date of the impugned order? 23/8/23.
I have already certified copy of the order.
It is 23/8/23. Come to page 84.
Certified copy I have annexed already, madam.
Huh?
But I am not giving number, madam, in the certified copy. Impute order or before the authority.
23rd August 2020.
23/8/23. Yes, that is the order.
Page 21 of my opinion opposition. Of my opinion.
Hmm. Hmm. And what is the date of application on plain paper? What is the date of plain paper application?
In paper application, my lord, page 32.
Page
32. Other applied for benefits.
28th December 2012.
Where is the date? We don't. Where is the date on?
In my affidavit in opposition, paragraph 1, page 2.
2010.
No, date
Father
of date is
applied.
24th April 2010. And pro forma application submitted on 28th December 2012.
In the plain.
No, we are not asking you that. We are asking you this plain paper application. What is the date?
Page 32, my lord. On 14/6.
14/6. 14/6/2000.
Yes, my lord.
14/6/2010.
Sir, order your lordship also recorded.
And in 2010 also, this requirement of pro forma application was there based on the 2008 EMP. Where is the provision in 2008 EMP?
Paragraph 4. May I hand over a copy?
No, we have it, 2008 EMP.
Page 39 and 41.
EMP 30. Yes, perhaps it is.
No.
Yes, which page? Application? Which page of the application?
Have a look at that. Have a look at this circulars on appointment.
Page 41. Paragraph 4. In 6 months from the date of death. The prescribed form.
Order of the London Tribunal is recorded that the application was made in time, within 2 years.
No,
The
no.
order. Yes, I
Within
am
6 months,
reading, my lord.
within 6 months from the date of the disease template.
No, recorded of the tribunal.
Circular said The dependent of an employee seeking an appointment on compulsory grounds shall henceforth be make an application in the prescribed form within 6 months from the date of the released employee. If no such application is submitted within this stipulated period, it should presume that the family does not require immediate financial.
No, you see, they are to apply through the proper channel, through the employer, that is from the place of posting.
In the prescribed form.
Yes. So who are to supply, who is to supply the prescribed form? It is from the office.
No, prescribed form is available in the website.
It is
No.
their circular. After the date, they will, my lord, advise. They not supplied any pro forma
That is the 2016 circular, but that took place in 2010.
Gives them this warning. You see, these forms are usually provided by the office where he is, because entire thing, if you leave it to the website, you see these persons who are in a helpless situation.
This has been published in the official gazette.
Yes.
This has been published in the official gazette.
Maybe, but so far this
As soon
form,
as they publish in the official gazette, everybody knows.
this is published very well. Question is, if this prescribed forms and all these things, this must be available in the office. It's a 2008.
No, 2008 circular, but that took place 2010. That is on 24th of April 2010.
My lord, they are circular matter in the affidavit in opposition. They have made a annexed. My lord, I am reading, my lord, page 20 of their affidavit in opposition. They are circular. Their affidavit in opposition, kindly page 20.
That is in 2016 circular. How can it be given retrospective effect?
But my lord, just I am reading, my lord, if you lords will allow me to. Page 20. The concerned authority in department office should meet the members of the family of the deceased government servant immediately after his death to advise and assist them in getting appointment for compassionate appointment. The applicant should be called in person at the very first stage and should be advised in person about the requirement of formalities to be completed by him. A record of such meeting should be kept with the office of the controlling authority and authority of an appointing authority. All cases compassionate appointment should be disposed of by the administrative department, preferable within 6 months of the receipt of the report of the three members screening cum inquiry committee. A three-man committee filed the report and also recommended my application. No consideration. Till they are sitting tight. When I moved before the administrative tribunal in the year 20, the authority, the administrative tribunal directed the authority to consider.
After 2010. In 2010. When did they?
Beneficiary mother applied.
Huh?
Mother applied for his son.
That is what we are saying, June 2010. That is when she has applied. It was not on the pro forma. That's a different thing. When they have rejected it. When have
No
they?
rejected, no, nothing communicated.
So it was kept pending in that way.
Pending, my lord. They are all, the matter was pending, my lord. Application.
We are asking you when they have rejected it.
Rejected, my lord, in the my lord, order, my lord.
23/8/23 they have rejected it.
43 page, my lord.
Come to page 85. You're saying not rejected. We don't know how you are saying not rejected. This rejection has come during pendency of OA or prior to OA?
My lord, first stage. Well, first stage, my lord, was not first, my lord, pending, my lord.
No, how that will be?
720.
2023.
We are asking you whether this rejection has come before filing of the OA or after filing of the OA.
Filing of the OA.
Please respond to what we ask you. So it was passed during pendency of the OA.
After filing the OA application.
And after you made your application in June 2010, did you ever pursue the matter?
My lord, they time to time making application, forwarding the application to the director of festival, but not consider. And last time, my lord, they recommended my application. Well, page, my lord, page 40.
Page 40.
40.
Inquiry report.
Or last page. Last paragraph. For last month of
No, this is of 2012.
that time when application was recommended. Three-man committee was filed the report.
There is a recommendation.
There also said my family is a distressed family. So recommend.
Again, we are asking you, in June 2010, you made the application. After that, what steps you took till filing of the OA? Any reminder sent by you or any?
My mother already so many reminders we sent by
41 is not the reminder, sir.
other application 43.
40? This is your reminder. We don't think so.
The lady.
No, this is not the lady's reminder.
No, Gita Shortkar.
This.
Gita Shortkar.
Then why it is
Mother applied.
deputy director?
The application of Gita Shortkar.
What does it say?
He applied for our son.
Can't understand.
That simply says that after the death of the husband, it's suffering. So, as something in the
Yes, mother also submitted the no objection.
page 44, submitted the no objection.
Page
44. Next page. You know, this 44. No objection of the
Forward.
No, this is earlier. This is prior to this. 44 is prior to 44. 44 is of 2013.
This is 16.
What is the date of this? Page 44 is dated.
December, my lord.
12 December 2000.
17. 12 December 17, 2017.
17. Where have you stated the date? So this memo of 2013 has been responded to you in 2017 after 4 years.
Yeah, not Skype. 13, 13.
This is the office memo by the deputy director to the director.
12th of December 2017.
An office memo.
After 5 years.
Office correspondence.
This is not a reminder.
No. Office memo.
Yes.
This one. This. Okay.
This is earlier in time.
16.
This is of 2013. This is in reference to 21/3/13.
Memo.
So this must be in 2013. It's
So page, apart from page 43, any other representation made from your side to the authorities? So only this 43.
which is of 2016.
These people without maybe something public asked to come in and again till the knock the doors of the court.
See,
We have also my lord, all medical certificate of my mother.
It's all right. Same same cannot be different. Same.
Not only a decision on this point.
No, I've got only one regarding 162 circular. 1955 Supreme Court cases 553. That what is the effect of all circular issued under Article 162?
All circular?
This type of circulars are issued exercise of power under Article 162.
Yes.
It has legislative force.
Correct.
Because occupied field is legislation. Provided the state government can issue the circular, I've got the legislative power. That's why Justice Bijan Mukherjee in paragraph 15 said that.
Which judgment you are relying?
If a petition was challenged under Article 32 in Supreme Court, challenging the issued by the Punjab government, taking over the power of the booksellers or textbook suppliers by 162 circular. In that
See, the only issue is when you say that application is to be made on a within the time.
Yeah.
Whether within the time and pro forma both are mandatory,
yes, ma'am.
or only the time is mandatory and mere application would suffice. That is why we had asked you to come back with, you said that you will examine whether any court has decided this.
This particular part, whether this circular has got mandatory or directed.
See, there are three circulars to be read together. EMP 30, EMP 251 and the last of 2016. Because 30 has been clarified by these two subsequent circulars.
2016 circular.
The last circulars, it has come into existence because it says departments are facing difficulty. So therefore, it has clarified the position emerging from the earlier circulars. And doing that, the state government says that the authorities must reach out to the person who is left in destitute by loss of the breadwinner and inform him or her as to what action is to be taken, which pro forma is to be submitted. 16 goes to the extent of saying that a simplified pro forma also has to be evolved. The earlier pro forma is too complicated. So the intention of these circulars have to be given effect to.
It clarified the 2013 circular, 15 circular and 2016 circular, not 2008 circular.
Yes.
But kindly see.
No, you kindly see your impugned order. At page 85, in all the notifications issued since 2008, 30 EMP, 251 EMP, and 26. You are reading all three together. Your authority is reading all the three together.
2013 and 2016.
No.
Paragraph D. In the present case, date of the deceased employee.
No, paragraph D comes after C.
C.
So you have to read C, then only you can read C.
Of the notifications since 2008, notification number 30.
30 MP. Yes, all three have been considered.
2nd April 2008 up to issuance of the notification number 251 dated 3rd December 2013. The time limit for making application for compensation was specified for 6 months from the date of the date, which was reversed lastly by notification number 26 EMP dated 1st March 2016, which fixed at 2 years from the date of the deceased employee. In the present case, date of the deceased employee on 24th April 2010 and the date of submission of the application, the appointment for compulsory ground is on 28th December 2012. So the applicant applied for compulsion upon ground after 2 years from the date of the deceased employee. 2 years from the deceased employee.
That is a wrong fact recorded in the order. Prima facie. Application was not submitted 2 years. Pro forma was submitted.
Pro forma submitted.
Application, it is not in dispute that application was submitted in June 2010.
In the plain paper is not an application. Application must be.
So therefore, it is, you can say pro forma was not submitted.
Pro forma application has to be first because in the prescribed format.
That we are trying to see from where you say that it has to be pro forma.
Can you see the language?
Therefore, we said whether both are mandatory. The time frame and pro forma or only time frame is mandatory.
2008 circular, can you see the language?
Yes.
Paragraph 4. The dependent of an employee seeking an appointment on compulsion ground shall be henceforth make an application in the prescribed pro forma within 6 months from the date of the deceased employee. This is mandatory because his name will be there, income will be there, number of members of the family members, dependent number of members.
See, mandatory can only be if it is coupled with a circumstance for failure.
Not necessarily mandatory.
Yes. Otherwise, how it will become a mandatory unless there is no consequence for failure to do so.
Did not provide the penal clause that it has.
So now you read further the next sentence. If no application is filed, then no application. If no pro forma application, now it does not say.
No, but application does not mean the application the prescribed form.
That we don't know. Application has not been defined to mean a pro forma application. And this rule, it deliberately uses two terms. In the first sentence, it says making of an application on pro forma within 6 months. In the second, when it prescribes the consequence, it omits to say pro forma. It says if no application is made.
But the language is no, if no application.
Yes.
Means does not mean that the application in the plain paper.
That is your interpretation, but application has neither been defined.
That
it means a pro forma, nor this. Otherwise, why two terms will be used in the same?
How the executive could insert a word which has been issued in the name of the governor? How the executive could insert a word in the executive circular issued in the name of the governor?
Yes.
162 circular it is.
Yes. So therefore, whatever it says, we have to go by that.
But
it says making application within 6 months on pro forma is required. It says if you don't make an application within 6 months, then it will be presumed that here it does not say if you don't submit the pro forma.
That language is not there.
Not there. So it is a. So are we to insert something here?
My respectation, sir, executive cannot insert such a word. Whatever will be said by the governor in exercise the part 162, we should be
correct. So if we examine this, are to we insert pro forma here? If it was so mandatory, you could have said that application will mean application on pro forma. That you have not said. You have not defined application. You have used two terms. The government has used two terms. Once it has used an application on pro forma, the next it has omitted to use pro forma.
Either omitted or not omitted, but I cannot say.
It is prima facie there. How can you not say?
No, but the application means in the all particulars in the prescribed form.
Submitting that we have heard.
If it is interpretation is given that prescribed application means any applications. That means no, sir. Nobody will file a.
Point is which interpretation is preferred is to be preferred. One which requires inserting something which is not there, or one which must be read, must proceed on a plain reading and in furtherance of the objective. Now the objective, what is the objective, is further supplied by the subsequent two circulars, 2013 and 16. Because your authorities are finding difficulty, they say now it has to be done there like
But
this.
whether 2016 circular can be made applicable in respect of the employee who death took place 2010.
That is clear from the circular itself. It says all pending cases, it will be governed by this. The government itself says.
That is also in the 2 years. 2 years. There is no.
But it says this will apply to all pending, so there is nothing left to ambiguity.
No. But 2 years from the date of the this employee, he has not filed application in the prescribed for within 2 years also.
Just one line from this circular cannot be made applicable to him.
No.
The entire circular has to apply to him. So the entire circular would include the timelines. The entire circular would include the further requirements in 10BB, the further requirement in 14BB. Everything will now apply. Just one line cannot be applied from this circular. Taken out and applied to reject his case. We don't know whether it is liable to be rejected. But taking out a single line for rejecting his case, can we allow that from a notification? Or it has to be considered as a whole. The rights of the petitioner have to be considered as a whole.
When this application was placed before the committee, that is at page 6 of the.
You see clause 14BB at page 121. What does it say? At page 121, see here 120. It is how much more clear can it be? Just see 14BB, page 121.
Belated request.
No, sir. 14BB, page 121.
Oh. 14BB.
14BB.
14BB. Any undisposed of cases where a death or incapacity has occurred prior to the issue of this order. That is 2016.
Correct.
But after issue of the order dated 2nd April 2008.
Correct.
Took to the effect if
it complies with these instructions, you are saying it is not retrospective and this and that. This is what your government has decided. This is the government's conscious mandate under this circular. And it says any case after the 30 MP. So his case will fall in this. His case is after 30 MP. It's of 2010. It's not prior to 2008. 14BB says if it has after the issue of 30 MP. So his case is after 30 MP.
2010.
Therefore, we asked you to go see whether the issue has been considered by any judgment.
At least by
You could not find.
But I could have certain.
Then you come with whatever citations. We want to decide this matter. We will decide this. We'll take it up in the regular bench. But you come with whatever citations. And maybe it will be advisable to have a paper book.
Yeah, that would be better.
This way we cannot proceed. It is totally.
22,
22, I beg to appear for the petitioner, my lord. My lord, as per my lord's direction, I am filing my reply, my lord. My lord, matter pertains to land losers, my lord.
When have we fixed?
My lord has kept it after 4 weeks, my lords. But because,
Your case was also at that.
yes, my lord.
So what was it? When was it?
My lord has directed that after it will appear after 4 weeks, my lord.
When did we pass this order?
My lord has passed this order last week, my lord.
So that means it will come after 3 weeks.
After 3 weeks.
What is this reply?
My lord,
Reply is taken on record. Full stop.
yes.
The matter of 29 of 2024, SS Natural Resources Private Limited and another.
Lord, this is that matter, my lord, where
Today we can't proceed,
I had practically finished. It was only, my lord, a question of 10 minutes left, my
but
lord.
today we can't
Yes,
proceed.
my lord, I,
So when? The question is when?
but, whatever, my lord, it will be.
Any day, my lord, your worship.
No, you please give an agreed date between the two of you. Yes.
But is it possible, my lord, on 21st, which is, my lord, a Thursday?
Thursday.
Both of you are agreed. The
But it was before, my lord, the other. My lord.
yes, yes. This
Sorry, yeah.
matter is especially assigned to a bench.
Grateful.
Item number 2.
I understand it's not today. Only thing is that today was the date fixed in the code below. Tomorrow.
Instructed is tomorrow.
So I've been told that.
That bench is not available. What can be done? We just not today will not pass any order. Not.
Like, can it be tomorrow at 10:30? If subject to correction, because why I'm telling.
Yes, it can be tomorrow at the top. Tomorrow listed at the top. This matter. Item number.
Can it be taken away to tomorrow? Tomorrow 10:30. I have some personal.
Where is he? Where is your counterpart? So let it roll over. Let it roll over to the same time. We'll see if there is something you mention in the morning. The bench will be there. We'll just let it roll over. No orders. Tomorrow same time.
Today it's appearing. Today it's appearing, my lord, at fixed matter at 2 p.m. Then, my lord, tomorrow it will be at 2 p.m. my lord.
Yes, it will be fixed at 2 p.m.
It is understand between us that I will pray for adjournment in the court below, my lord. He will not.
I have already on the earlier occasion, but I didn't oppose and the matter was adjourned automatically.
He has said on Friday also, so we don't expect that he will go back.
Even the appeal will be admitted. The stay application is to be heard with a single.
Obviously.
That even
And there you have to be heard.
I will instruct them.
And there you have to be heard.
Yes, Lord. And that.
Yes.
Item number 3 to 6.
Appear on behalf of the response.
Same position, we just not today.
Item number 7.
So this was the analogous. No, no. Today, yes. Yes, next. Whatever next, whichever matter is fixed at 2 p.m., call those matters first. Yes. At 2 p.m. it has to be called. All matters which are 2 p.m. call them. Now proceed.
Item number 20.
Yeah. 19.
19 was fixed. Why you have not called it?
19.
Huh? When? Oh yes, that was adjournment was sought up earlier.
Not at our instance, Millard, it was no one informed us.
No, from your side only.
No.
20.
I'm from the respondent.
Yes. No one paid for an adjournment from us, to the best of our knowledge.
$19 was called or not called? Then why you didn't call 19? Telling you all the 2 p.m. matters, call it in why?
দিলেন
65 কোথায় আছে? 19 করে রাখ তো সাবধান হবে দরকার নেই।
Millard, matter which is before your lordship, Millard, is assailing an order made by the tribunal, Millard, at a stage where, Millard, the person questioned the inquiry report, the charge sheet. Millard, he
The tribunal was not inclined to interfere. Thereafter, matter travelled to your lordship's court after a substantial number of hearings. Now the position today is, there is a subsequent change, which we have indicated, in the application. After the inquiry officer's report, the disciplinary authority, in terms of their provisions, served on me the views of the authorities, insofar as the proposed penalty is concerned, to which, a response has been made, and I have been now given a penalty, awarded a penalty. Penalty is, a portion of my pension has been reduced. Now, today, your lordship is looking at a matter, where the disciplinary inquiry itself is under challenge. Two things need to be told to your lordship. First is, one aspect of the matter can be that whether, assailing the final order of penalty, which is in pursuance of a perfunctory inquiry held against me. Why I say perfunctory? Because, if your lordship sees the nature of allegations vis-a-vis the evidence laid before the authorities, one fact would emanate therefrom is that there was no evidence worth its name which could have been relied on in order to make the inquiry report. Because the evidence which was laid was apparently not proved during the inquiry. Not proved. It was just a mechanical exercise. X number of documents were marked as exhibits. No one produced those documents. No one proved the contents of the documents as to what the documents were. And ultimately, relying on those documents, a conclusion has been reached by the inquiry officer that, my complicity is established. The nature of allegations, first submission to your lordship is this charge sheet is an offshoot of a CBI recommendation, because, why? The allegation against me is, contrary to my salary, whatever I was in receipt of, there were certain movable properties, which was purchased by me, which were purchased by me for a substantial length, starting from 2006 till 2012, 2013. And, ultimately, the charge sheet here is dated 2019. This charge sheet is on the basis of the recommendation made by the CBI. Now, again, there is one limb of judgments. One, the law is whether, on the self-same allegations, both proceedings can proceed simultaneously. Insofar as the criminal case is concerned, there is, it has not proceeded to the stage of charge sheet. It is still there pending before the learned court below. Wherever it is on, this criminal case is going to take an endless period of time. Now, on the basis of the recommendation by the CBI, this charge sheet was issued. Now, if your lordship kindly sees the inquiry report, I invite your lordship straightway, because the inquiry report is also under challenge in the writ petition as well as in the original application. The tribunal was not invited to go into two things. First is the tribunal did not allow a peep into its mind as to whether the evidence laid before the disciplinary, before the inquiry, during the inquiry, whether those evidence could have been relied on in the absence of any evidentiary value thereof. Why evidentiary value? Because the evidence was not laid in a manner known to law. In a manner known to law. It is the duty of the disciplinary authority through the presenting officer to produce the evidence through witnesses, and the contents of the evidence laid before the authorities, as well as the contents of the material produced during the inquiry, according to my humble submission, it needed to be proved before it could have been relied on. Now, if your lordship first takes the inquiry
for
report.
the question that arises is, that if as per the perception of the charged employee, the evidence is insufficient or not laid according to law, then instead of disciplinary authority, the tribunal has to take up this consideration.
Well, that consideration the tribunal failed to take.
Whether the tribunal is required to go into this or the disciplinary authority is there to see whether the inquiry officer has proceeded as per law or not.
Your lordship is correct. Ordinarily, the law is the disciplinary authority is supposed to see.
So where is the extraordinary circumstance?
Here, if your lordship sees,
Because it's not in accordance with law.
please see.
No, we are on the legal issue.
Yes.
We are not saying that we are not saying it was laid according to law. We are not saying the material was sufficient. We are not saying it is material was sufficient. What we are asking you is, even for the sake of argument, we take it that it was insufficient, it was perfunctory, there is nothing. Then the tribunal or court is to examine it, or it remains for the disciplinary authority to examine.
If I may say so, the Supreme Court has very recently laid down the law to the extent that the court will always look into.
No. We are not asking you that. The inquiry officer's alleged infirmities, it is to be, therefore, obviously, there can be no two opinions about it.
I am given a chance to.
And you have availed that chance now in this case. Yes.
And not only that, it's my duty to point out that after the inquiry report and everything, after my representation, in the can, what they did is, can 1 of 25, they served on me on 3rd January 25 when the matter was pending consideration. The advice of the UPSC, that is at page 18 of the can, to which also, the writ petitioner for your lordship has responded.
Therefore, we are saying now whatever matter was brought before the tribunal or before this court, that is over. The first thing is whether at that stage the tribunal or the court is to step into the shoes of the disciplinary authority or not. That is the first issue. Then only we may proceed or may not proceed to look into the alleged infirmities. The second is post submission of inquiry report, opportunity availed by the petitioner that subsequent development is there. He has participated, disciplinary authority has passed an order. Now, what is the remedy?
If I can, ordinary remedy is I have to throw a challenge.
So therefore, what is extraordinary?
Extraordinary is,
and where does the court say that in extraordinary circumstance, in place of the disciplinary authority, the court should intervene?
My humble answer to your lordship is twofold. I cannot avoid the charge sheet today, though I have retired. There are certain allegations of, this procuring, disproportionate.
Appreciating the entire circumstance, we last recorded the order.
Yes.
Now, therefore, whether again we are to go into the entire thing.
That day, the only understanding subject to correction, it fell from my lord, that whether, there is an appellate forum.
Correct.
Apparently,
No, we are still saying that. We are not on anything different.
Incidentally, the appellate forum is the honorable, ordinarily the law is the appellate forum. Here is the honorable His Excellency or Her Excellency, the President of India.
That is in many cases, nothing unique.
That is the law.
That is.
Now, here what I find is the impugned final order, though not impugned technically in the.
Never challenged by.
Never challenged. 24th April 2025 is an order signed by the Under Secretary to the Government of India, Ministry of Communication, but by the order and in the name of the President.
We don't know. Therefore, we are not going to look into it. You have a remedy of assailing it before the proper forum, or you have the remedy of availing an appeal. If you say that appeal is now redundant because the appellate authority has already applied his mind, we don't know. That may be a ground you may urge before the. But can we look into it directly?
What I was respectfully submitting, there are two things. Today, your lordship may, permit me to assail the entire thing once again before the tribunal. That is
the moment you assail the disciplinary authority is
that
finding
has to be
everything.
challenged there.
Everything will.
Now, my lord, if I can persuade your lordship to independently of the disciplinary authority's order, if your lordship finds infirmities on the face of it on the inquiry, then what happens? Two things, my lord, may happen. Your lordship would remit it back from that stage of inquiry for, my lord, further evidence and everything in accordance with law. That is one view possible.
Therefore, you are arguing before a division bench.
Yes.
Now, if we do this, then everybody will be obliged to look into an inquiry report instead of the disciplinary authority. We ask you, therefore, as a proposition of law.
As a proposition of law, I cannot argue.
Then how can we see the difficulty?
The
difficulty of your argument is.
Difficulty here is, my lord, had the gentleman, my lord, ordinarily, I am telling you, appearing as I am also an officer of court, my lord, apart from appearing for the petitioner. My lord, the issue is legally, whatever is falling from my lord is the correct proposition. It has to, my lord, be independently challenged. This 24.
Because the writ court cannot go into it.
Ordinarily,
both parties have to be
But
heard, the
again,
document
there are
has
these-
to be seen, and even after it is seen, if it comes before us, you know, we have a very limited scrutiny.
No, there your lordship has enough scope.
We have a very limited scrutiny.
My lord, according to me, my lord, at least
According to
this-
the apex court, we are confined to the decision-making process and not the decision.
A divergent, my lord. This is one of the latest on the subject, my lord. This is 25 SCC online 891 copy. SCC online 891.
Yes.
Why should we
Simultaneously,
The authorities order before the tribunal, we can't stop it. Yes, which paragraph yours?
please see, first is the challenge. Is to a judgment and order dated such and such. It is laid by the Uttar Pradesh. It is laid by the Uttar Pradesh unsuccessful writ petition. The impugned order dismissed the writ petition of the appellant, wherein the final order of the UPS Uttar Pradesh State Public Services Tribunal was under challenge. The tribunal set aside the order of punishment, imposing a penalty of this with a 5% reduction. The facts of the case are of great significance given the key arguments advanced. Hence, we find it appropriate to briefly narrate the events having a bearing on our decision before proceeding to examine the merits of the right.
Therefore, that's what we are saying. Unless the disciplinary authority's order is challenged, where is the question of going into this judgment? Whether we are
Your
to
Lordship
go
is
in.
correct. Just, my lord, for the sake of, my lord, kindly seize the issues, my lord, kindly.
Whatever it is, this is after the disciplinary authority's order was challenged.
No doubt.
Then,
now, my lord, two things, my lord, today, I will, my lord, then, my lord, request your lordship to, my lord, allow me to go back to the
we are
tribunal.
not going to say anything. We
Because
will
the
leave
tribunal will
everything
not be
open.
influenced by its previous order.
We will leave everything open in view of this, the development subsequent to filing of the tribunal OA and the writ petition. It is open to you to avail the remedy in accordance with law. That's all. We have nothing to say. Whether you will go to the tribunal, you will exhaust an appellate remedy. We don't know what you will choose.
No, appellate remedy is not there, but the tribunal.
No, appellate forum we said.
The appellate forum is not there. Because it is an order issued by the President of India.
There has to be an appeal against the
My lord,
disciplinary
that
authority.
Mr. Ghosh can my lord, throw some light. I don't think so, my lord, there is an appellate forum to it.
You know, there may be appellate forum, but I am not, my lord, sure. So, my lord,
There must be an appellate forum. There has to be.
let him avail his, my lord, remedy
Anyway.
in accordance with law, my lord.
Anyway, you may avail the remedies. What is the date of the DA's order?
24th April 2025.
It's in which can?
Can one, my lord.
My lord, only two things. My lord, if I may most humbly, my lord, the disciplinary proceedings matter, my lord. Usually in this sort of a matter, my lord, ordinarily an affidavit would not improve the whatever is on record. What I was humbly beseeching your lordship, if an order can be passed by your lordship, that in the event, my lord, I approach the tribunal may look into it and, my lord, decide the entire issue within a time fixed by my lord.
Let us pass the order. Let us pass the order. let us frame the order. Yes. Where is the disciplinary authorities order?
Milord, that is at page, Milord, 18. I'm sorry, Milord, page 53 of the CAN 1.
A5, A5.
A5.
This can one.
Yes. Milord, বলে দেখছি।
And where is the OA in the brief?
Milord, OA in the brief is, it begins from page 81. The reliefs,
Page 114.
yes. That is the charge sheet, 27th December,
Yes.
the IUS report.
Yes, we have seen it. Third learned advocate
What is the 50?
It is also prayed that
Number 20.
don't call it tomorrow.
Number 22. Twenty-three.
Lordship, I am appearing on behalf of the respondent.
Order ka copy do.
Yes.
Yes. Last occasion I have made my submissions. Thereafter, my lord had passed an order instructing, directing them to make their submissions on order. To na chalo. You have the copy of the order.
No, because you filed certain documents
Yes, my
on that
lord.
day.
Yes, my lord.
Yes. See, this becomes very difficult for us now. After you go, after submitting all these documents, it becomes impossible to deal with the issue.
My lord, may I suggest something?
Yes.
My lord allows me to make a compilation of kind of paper book.
Thank you. That is what we were trying to suggest. Please do that. Otherwise, it becomes impossible.
Give me 3 weeks time, my lord. In the
Why, sir, 3 weeks?
2 weeks. No, it's
Lordship, may I submit?
that's why I just take an extra week normally. Then
Army should do it on war footing. 2 days.
my lord takes it up sometime in middle of September.
Later in
Lordship, may I submit a few points?
My lord.
Lordship, may I submit few points if allowed?
you are appearing in this matter.
Yes, Lordship, I am for respondent.
Respondent, but somebody is appearing for the respondent.
He is my associate, Lordship. He will provide a copy of some orders if required.
Yes, what is it you want to say?
Lordship, on the last date, they have provided some additional documents on affidavit. I want to say only that the relevant page is only page number 16, which is already part of their counter affidavit, which they had filed in AFT. So there is nothing new on this.
Let them file the paper book. Let's see. Yes.
Otherwise, Lordships have decided such issues in so many cases.
Every issue is almost decided one way or the other, but still they keep coming up. Just I have seen the Punjab and Haryana High Court that why every order of the AFT is being challenged.
Lordship, more than 400 orders have been, petitions have been dismissed by Delhi High Court.
In a routine way, without exhausting the High Court's remedy, we will not giving him. Why such an opinion is being created by your conduct before the High Court? there any litigation policy? Is there any forum which takes a decision going through the records whether we should file a case or not? Or it is just that you give an opinion and it's filed? But ultimately, this litigation is also at the cost of the public money.
Exactly, my lord.
And the court's precious time is lost doing the same thing. At least 2 cases we have seen already decided still same thing. You don't know, in this case, maybe you have a good case. We don't know. We are not.
But this is more a little factual based, therefore probably might be a little different.
Yes.
No, not at all, Lordship.
Is there any forum which makes a conscious decision that yes, in this case, we are not to file a
Appeal or not?
a writ petition? How many cases you have decided not to file a writ petition?
I'll find out and next day I will inform you.
And we are just curious.
I will do that. I will myself find out.
Lordship, very sorted if they are still, if they are persisting.
Let's see.
Lordship, one more submission.
Call the next case. Yes.
Lordship, one more submission.
No, it's adjourned. What submission? Call the next case.
Your Lordship, there was an interim order as well in this matter.
Huh?
There was an interim order in this matter that may be extended, Your Lordship.
No, but we are not informed about any interim order.
No, Lordship, there is no interim order.
What is the date of the interim order?
Required, my lord. Once my lord has passed that order, that applies. So,
Lordship, there is no stay.
All right, call the next.
There is one. My lord had said that they will not move this.
Highly obliged, Lordship.
Well, in this matter, I'm trying to give a new lease of life to the petitioner because there's a stratum of fact. And if I will fumble, my lord, kindly excuse me on that. Just I put the place of snippets of the fact ballot, thereafter go the annexures and the law points involved or the fact as well.
What is wrong with the tribunal's order? When the same issue has been dismissed, then why the tribunal is required to go into it again?
The same issue, my lord, pertaining to this writ petition, my lord, the issue before the tribunal was asking for the waiting list candidate. The waiting list candidate approached before the tribunal.
WPCT 81, where is the order
Yes.
passed in WPCT 81?
WPCT 81, my lord, kindly come to page 378 of volume 2. Because the numerous writ petitions filed by the railway was allowed. And the petition for that reason filed before the tribunal was with regard to the creation of the waiting list because there was a vacancy. Here, Valet, we are not asking for any waiting list vacancy. We are impaneled candidate and we have been denied employment due to interpolation of the list.
When we are reading, can we hear you?
I just try to assist you, Lordship.
How can we hear you or how can we read if you are speaking?
When I stop, Valet, you will also be read. The decision of the Honorable High Court Pilot starts from 386, para 12. Hmm.
Yes.
The order which I assailed before the Honorable London Tribunal ballot at is 591.
No, what do you want?
Let the vacancy position is still existing and we are the impaneled candidate. After the interpolation of the result, we filed that particular petition before the Honorable High Court, but on the ground of technicalities, the merit of the Honorable Tribunal was never gone into merit scrutiny before this Honorable Court ballot. So therefore, ballot, the interpolation order per se, from which my rights has been extinguished, is a matter of concern. And since we have qualified
That
all the
issue is
stages,
already decided by the writ court. In specific terms, impaneled candidates claiming existing vacancies cannot be granted. You must have read the order, therefore we are saying.
I have read it, ballot. The only impediment which I am getting, ballot, that the validity of the panel of 2 years.
That issue is closed, cannot be argued now. We cannot go beyond the coordinate bench.
The coordinate bench, ballot, has passed an order with
Coordinate bench in so many terms, the same similarly situated candidate said impaneled vacancies existing. This court said cannot be. It is a stale matter. 5 recruitment processes have already gone by. There is no scope. There was no provision for creation of any waiting list. And the number of vacancies which were advertised, we cannot direct for going beyond. Now, so therefore, what remains we are asking?
Ballot, my only point is this, ballot. Since this particular writ petition disposed of by this honorable court, ballot, on a ground of the creation of the waiting list, ballot.
No.
And our
No. That submission, with great respect to you, we don't accept.
In that case, ballot, kindly come to page.
You kindly come to page 388.
Yes, I have gone with ballot. Kindly come to page 9.
Don't say. See what you are asking. Exactly that same thing has been considered.
If I failed to apprise before a lordship.
No.
For the 591 is concerned, then I don't have any case.
We are not going to see anything. We want you to tell us what you want. You have told us. You say we were impaneled. There are vacancies.
Yes.
This aspect has been considered. Why should we go into anything else? When the coordinate bench has already rejected that this cannot be accepted, the recruitment process of 2006, vacancies were advertised in a particular number. In fact, at least 5 submissions have been considered. In that case, 5 submissions, unless we have missed to mark anything else.
That is, you're right. Your lordship is right.
5 submissions were considered.
But we are not a party to that ballot.
You may not be, but how can we travel beyond the coordinate bench? We cannot. So the tribunal's decision, we are asking you, what is the infirmity?
The infirmity, my lord, is
Tribunal says this issue is decided up to the High Court. I can't do anything. What is wrong with the tribunal, sir?
the judgment of the new cause of action start from 591, your lordship. Once your lordship will see that paper, that particular scrap of document.
All in respect to the 2006 recruitment process. We are not going to see anything here.
That is there, that is a fact. But the vacancy is still
You may keep writing, you may take it RTI, that is not improved. Even that aspect the court has considered. RTI information will not grant any right, not vest any right.
I am not.
It will be governed by the recruitment advertisement and the number of posts specified therein.
And my contention, my lord, if your lordship will peruse
591
that
may be another RTI application by you.
591 is the reply of the railway under which where I stands, where my case stands, my lord. That is the point. And from this particular order, I decided, or rather the petitioner decided to revisit the entire matter before your lordship for the better consideration.
That
Because
will
it
give
was
you a fresh cause of action, 591.
Yes, my lord, that is.
What have they said in 591?
Stated, my lord?
Yes.
That is the letter issued by the senior personal officer recruitment. Application submitted by Samar Kumar Mandal and others is thoroughly examined by this end. This is to state that panel against employment notification 0106 was revised as per the judgment of the Honorable CAT Kolkata in OA number 706 of 2009 and others dated 9/4/2010. After revision, some candidates were interpolated and same number of candidates from the bottom of the panel were excluded. Modified panel of 5512 candidates were published on 21/1/2012. 61 candidates filed writ petition before the Honorable High Court Calcutta RRC ER, made a concession before the Honorable High Court Calcutta that a 61 writ petitioner shall be considered for appointment in light of the CAT Calcutta order dated 9/4/2010. Later, another panel of 214 candidates were published on 11/8/2012. Out of the 61, some writ petitioner got position in the panel as per their merit. Now, the unsuccessful petitioner filed a contempt application before Honorable High Court Calcutta CPN number such and such. The petitioner concealed the fact that the application was dismissed by the Honorable High Court Calcutta on dated 4/3/2016. So there is no question for consideration the unsuccessful petitioner. Here, my lord.
So what is new?
Were you not an unsuccessful petitioner?
No, I was successful, my lord.
No, before the High Court, unsuccessful petitioner.
No, the
petitioner concealed the fact that the application was dismissed.
We were not unsuccessful petitioner. We were impaneled candidate. And after the interpolation, my name has not been taken into the final list. For that reason, I came before the Honorable High Court. But only.
How 591 gives you a new cause of action? It is doing nothing but recording a history.
No, that is valid because this particular unsuccessful candidate has suppressed the material fact that the CPN number has been
591 is issued to whom?
This is issued to the
who is it issued?
Appointment of with regard to the petitioner himself, Samar Kumar Mandal.
All right. So
Malik,
it is only reiterating the history. What is new?
This new is
how it will give a new cause of action? It is relying on what has happened in the past.
Malik, my submission would be since the CPN has been.
So if after this case somebody again writes a letter and they get then a different conclusion can be drawn.
Malik, issue is this: since the I was a successful candidate in all the.
You were never successful.
Yes,
you were impaneled. Impaneled and successful are two different things.
Impaneled, Malik,
impaneled means up to 3 times the number of vacancies or 10 times the number of vacancies. So that is not a successful. Successful is ultimately who emerges with the appointment.
So,
you were an impaneled candidate.
Yes, I was impaneled.
You were never successful.
So whenever there is a de-impanelment process would take place.
There is no de-impanelment process.
There is, well.
No, sir.
There is.
No, sir. The impaneled candidates, actually, though the original panel was challenged by certain people saying that we have been left out.
Yes.
There were certain directions for redoing the thing. When that direction was passed, those who had been impaneled, they came saying how in our absence such an order has been passed.
Yes.
Then the court said consider all.
Yes.
Then all were considered, panel prepared.
Yes.
You were in the panel.
No.
Much below the last cutoff. Now you are saying vacancies are remaining. Please take me.
Much below.
That is
that much below from which?
Maybe much below or one below, whatever. You are beyond the cutoff.
That thing we don't know, my lord.
You know for sure, sir.
No. How can, my lord?
You know
there
because
is-
you are impaneled. You would know. You can't say you
there
don't
is
know.
no allocation of the marks. It
We
is
don't know.
that
That issue is not left open. Marks is not left open. You were below the last selected candidate. That you know.
My lord.
And that person is already dealt with in the earlier order of the High Court.
This particular issue, when the Honorable High
Issue
Court
has been decided.
Just by the concluding ballot, when this particular interpolation order passed by the CAT ballot, we preferred a writ petition. 3 writ petitions were filed before this Honorable Court. Only on that
10, 20, who knows about 3?
The merit of this case.
Like you,
Ballot,
there may
when
be
the
at
matter was
least
going on, there was a concession
50 or
given by the
100 more
railway that this writ petition would be considered in a matter of the fresh impanelment. After giving the concession ballot, this writ petition was disposed
Your
of.
case did not come under the category of concession. So that is your grievance.
No. At that point of time, they have given the concession that 61 writ petition would be considered, but thereafter this consideration was never taken place, ballot was with regard to the
So did
petition.
you make any representation for concession?
Yes, I filed a CPN number for the contempt application. That contempt application disposed of with a direction that there is no mandate of the judicial order. So therefore, we cannot go into the merit of the contempt. So being agreed by that order ballot, we preferred a separate representation by filing a new OA before the Honorable Tribunal and by inter alia challenging the 591 order ballot. Then after ballot, the 481 petition, WPCT 81 is WPCT 81 is with regard to the creation of the waiting list where I was not a party.
What is the error in this order? You see, 10/1/2017. What is the error in the order? It is deciding your representation.
Yes.
What is the error?
The error, ballot, since matter was pertaining to the creation of the waiting list, we were already
There is no
paneled.
issue of waiting list, sir. Please don't say. Waiting list is closed.
My lord.
You know it very well. The court has in unequivocal terms said there is no question of a waiting list.
My lord. That is it.
Clearly turned down by the coordinate bench. There is no issue remaining of a waiting list. Even that has been turned down. Even your claim that for those who have been impaneled, considering the remaining vacancies, that has also been turned.
That has also.
In unequivocal terms, it cannot be done.
Yes, in one side ballot, but since 591 is before me ballot, so therefore I try.
591 is nothing. What is 591? It is
591
nothing.
saying since the contempt application had been suppressed by the petitioner, therefore we cannot.
That contempt application, what happened? We don't know ultimately what
These
happened.
are part of the records ballot. You
We
lordship
don't know that contempt application. What happened in the contempt?
Contempt ballot because the two
What happened in the contempt
it
application?
was dropped on a ground.
Then
No, ballot kindly.
Then if you
No,
want,
it
if
was
you
not a
wanted to
judicial order.
challenge,
It
you
was
could have
not a
challenged.
judicial order.
If you wanted, you could have challenged that.
It
Why
was-
we should look into it in a parallel proceeding?
That particular content proceedings was
will not
dropped
for a
on the ground. There is no judicial mandate because there was a concession.
We
Once the
don't
concession,
know. We are not going to go into that. That's not part of these proceedings. You chose not to challenge 591. You have chosen not to challenge 591.
520 would have challenged, man.
The contempt proceedings.
No,
The contempt proceedings were dropped as a result of 591.
No.
Yes, just now you said contempt proceeding was
Contempt
dropped.
proceedings were dropped earlier. Then after I filed the new representation, no original application was filed.
Therefore-
Inter alia challenging this order.
Therefore, we said after this case also you may file a representation, but will that confer a fresh cause of action? That is the point.
I'm asking to myself, if there was a
2006 recruitment
if there
by
would be
now there
fault
must have been
or
10
if there would be
recruitments at
fault
least.
on my side, my lord, I would the first person to discard this sort of litigation, my lord.
Sir, there is a fault on your part. The court has already concluded that.
My lord. Where I am not a party, my lord. kindly
We
confirm.
don't know.
And this is the 591 is standing before us, your lordship.
Raising the
591
same.
is not challenged.
No, that is challenge, my lord.
No, before the tribunal.
Yes,
before
yes,
the-
that is challenge. Kindly go to my prayer. What was I have prayed a prayer? Where is the prayer? This thing the page numbers.
No, you see, if there is a direction to reconsider, what purpose will be served? Will they be able to do anything? Suppose for argument's sake, we direct them to reconsider.
Reconsideration would be a Midas touch to this petitioner because there is no fault of them. That would be the Midas touch. My lord, already 5 different processes has.
I'm nothing, I'm
recruitment
asking nothing,
processes
my
have
lord.
been
If there is a vacancy, that would be, your lordship will consider that would suffice our purpose because
Is it your case that with regard to those 2006, those who are empaneled, they are absorbed in the subsequent vacancies?
no, this particular illegality on the vacancy on the, this is before the tribunal, I was arguing the matter. 2 or 3 persons has got appointment even after 2 years, my lord. So this is the state.
Question is,
my lord,
that
this is
2006, those who are empaneled like you,
yes.
were any of them given appointment? That is the only question.
No, there was a 2,400 vacancies are still existing at that point of
Well,
time.
now whether the authorities gave appointment to any of the candidates of 2006
Yes,
who were similarly placed of
Yes,
you?
yes. The authority has given several because there was a
No, those who are similarly placed like you in 2006.
there was a similarly placed pilot, the vacancy of total 5876. Out of that ballot, still 181 vacancies are left out and 2024 not joined. So I'm asking only for the consideration because there's a no part, no flaw of my rights ballot because there is a unwritten. If there would be any fault ballot, I would not. I will taken back this petition.
Exercise.
Where is that OA? Yes, I got it.
Yes, did you give the details to the authority that similarly placed candidates like you were given appointment, those who are empaneled? Then and only then there can be a ground by the authority.
There was one case. One person below the last cutoff was said that they have given. So it was from your OA or your representation, one person about whom you have said who was empaneled beyond 165 and who has been granted an appointment.
61 writ petitioners, my lord, they have.
Sir, please.
My lord, misleading, my lord.
Don't take us in history. You said now we want you to show.
Yes, my lord. What
You responded to his lordship's query
yes.
that yes, similarly person situated like you has been offered an appointment. Tell us which is that person, in which representation, in which paragraph of the OA you have said about this person.
My lord. Yes.
You go through it thoroughly. Tell us tomorrow, not today.
But I am only praying your lordship day after tomorrow and tomorrow, day after tomorrow, my lord. I will
Tomorrow ask someone to make a.
Yes, my lord. I'll do it. Deployed. Lordship.
925.
Tomorrow, day after tomorrow, whatever.
Item 25. Item 26.
Your Lordship, I appear on behalf of
All these writ petitions are by the same writ petitioner. By the same council. Up to 29. So all these matters not today up to 29.
Item 30.
Your Lordship, on item number 30, Ms. Chandrai Alam, learned senior advocate, is appearing in this matter. Your Lordship, Ms. Chandrai Alam, Your Lordship, learned advocate, is appearing for petitioner in this matter.
Yes.
Your Lordship, she was here. She is at her legs in another court. Your Lordship, I'm praying for a short passover, or this matter may be taken up tomorrow. Your Lordship, subject to Your Lordship's convenience. Oh.
Yes, come.
কপি দিতেন তারপরে এখন মানে we haven't been able to serve complete হয়নি তাহলে তো সেটা হ্যাঁ Lordship, before I open the case, Lordship, the the copy could not be served on the respondent, Lordship, because it has come with the instructions is addressee left without instructions. The AD card has returned, but the parcel has not come. So this is the predicament that we are in.
This was the position in February when we had passed an order to give the up-to-date position.
Yes.
So now we are in August. 6 months has passed in the meantime.
Yes.
Your Lordship, they have filed a contempt application. I'm trying to serve the learned advocate who is appearing in the contempt.
No, then let us see what is wrong with the order. Let us see Rule 31. What is Rule 31? Tell us. Why Rule 31 will not apply? The tribunal has said, according to Rule 31, calculate their service and 50% of the benefits you give them. as a qualifying service for the purpose of pension.
Lordship, rule.
Why Rule 31 will not apply? That's the only issue.
Lordship, he was not either he was a employee of the club.
No, where he is saying, who is saying he is not a quasi administrative member?
So
let us see Rule 31, whether it applies to this and whether the judgment of the apex court which the tribunal has relied upon, it does not apply in the case of this petitioner. That's all. Considering Rule 31, the apex court has held that for these persons who are employed in canteens, the board's policy is that they will come below those who are serving in the establishment as a casual employee or have been given a permanent status. Since they are to be placed below all these people for the purpose of regularization, they could never be regularized. Now, considering this aspect, Rule 31 was applied, saying that even if they cannot be regularized, at least 50% of the service rendered by them will be considered as qualifying service for the purposes of grant of pension, whether regularized or not regularized. The tribunal, relying upon decision of the apex court and Rule 31, said yes, you consider their claim for pension by applying Rule 31. So the issue is whether Rule 31 is applicable to these petitioners or not. Let us see what are the requirements of Rule 31.
Today I'm in a bit
Where is your reply filed before the tribunal? Let us see your reply.
The reply is Chip, 70. My reply is at page 73.
Page
73. Lordship. That we have got. Lordship, if your Lordship comes to page 78, Lordship, it starts from page 77, paragraph 6. I think that is Lordship, it further submitted that the Railway Ministry had formulated a policy. Lordship,
you are reading page 77.
78. It starts from the 77 last paragraph. 78, I'm placing 78, Lordship. Formulated a policy in the year 1977 for screening and absorption of quasi-administrative officers, unit staffs connected with the railways in terms of Railway Board's letter number so-and-so. It was further clarified that the staff of cooperative societies, canteens, commissioned vendors of the Department of Catering, etc., can be considered eligible. In CPO IR's letter dated 26/5/94, it was communicated that quasi-administrative staff who have worked at least 5 years in Railway Institute cooperative societies should be screened along with casual labor substitutes, and their names will be placed in the bottom of the list, in the screening list, They will be placed below all the casual labor substitutes and will be posted against Group D vacancies as a regular measure, as and when the vacancies are available. The applicant had joined in the railway service with effect from 4th of March 1996 after due screening and on availability of vacancies. His previous services as a library assistant in a non-railway organization cannot
Where
be
was he in which library he was working?
It was a Netaji Subhash Institute. It was
As a assistant librarian, he was working there.
yes, Lordship, Netaji Subhash Institute.
It's an Eastern Railway Institute.
Lordship, it was more like a club for the officers, Lordship.
Where is that bylaws? Where is the bylaws of?
Lordship, then I'll produce it, Lordship. I think I'll get a copy of it. Bylaws. Lordship, bylaws of the Netaji Subhash Institute. This is part 2, Lordship, at page 184. Lordship, if your Lordship comes to page 85, 204, all appointments, increase of pay other than annual increments, reductions, resignation, removal of full-time class 3 and class 4 staff of the institute shall be dealt with by the Committee of Management. The Committee of Management shall have powers to nominate the following. So, and so, Lordship, this is totally separate. It is true they come, but it cannot be equated with the gangman or the substitutes or the casual employees, Lordship. This is our contention, Lordship. Lordship, since the railway, I mean the railway not being the principal employer, as it is in case of casuals or substitutes or the other employees, Lordship, and staff not being paid, Lordship, we did not.
So who framed these bylaws?
That I have to seek instructions, Lordship. I'll have to seek instructions.
No, it is there at page 84. The committee are empowered to make bylaws to suit local circumstances, provided such bylaws shall not be inconsistent with any of the above general rules. So the bylaws are subservient to the rules which is being set by the general manager.
Lordship.
It is not as if some private association is framing the bylaws independent or exclusively from the railway establishment. Therefore, the tribunal said quasi-administrative. Right here it says, and this is by the general manager, and this is subservient to the rules.
Lordship, the payment is not from, I mean, railways do not have any.
No, that is why they say as per the local, you can do it, but it has to be compliant with the general rules. There is no absolute discretion given to this committee. And therefore, perhaps they have come out with a policy that if somebody is made to serve in such organizations, then 50% of their after 5 years, their 50% of the service will be counted for the purpose of, and that is what the tribunal has held. Is this? Can you get this general rules which is being referred? Will clarify everything.
I'll get the general.
This is a part of this document.
I'll get it.
You have all the annexures of the reply been based on record?
Okay, lecture. You can have to just check.
He was absorbed in 96.
96.
And when did he
Graduated in 2004.
4?
8 years.
So 8 years. So he's falling short by 2 years.
Falling short by 2 years.
And how long did he serve in the this?
That he served from
Must have been more than 5 years.
73, 90.
If he was not more than 5 years, he would not have been absorbed. So even if it is 5 years and 2.5 years is added, he will get the pensionary benefit. He's been serving.
1976.
When how long
he
he
was
has?
appointed in the railways in 96. Yes, Lordship.
That is his. That is the date of his absorption.
Absorption.
Oh, but in Netaji's
In
institute,
Netaji Subhash Institute, Lordship, this is I just checked his annexures.
must have said in his OA somewhere.
In his OA, Lordship, I'll just check.
In your reply, I could not find it unless I have missed. I found the date of absorption, but I could not find his
It could be
date of
annexed in
entry
the-
in. There is a statement in para 4.7. In para 4.7, there is a statement at page 40.
From 78. My instructions, it seems, are otherwise, Lordship. What the instructing officer says from 78, not 73. Just check the reply, Lordship.
So you do not dispute that he is a quasi-administrative staff.
He was a staff of the, that we have not disputed, but our only contention is that is not under the railways. That is.
Because this paragraph 4.7 also, there is no specific denial. You see your response at page 79.
Lordship, the denial is claiming to be engaged in the year 1973, but no documentary evidence has been submitted by him to corroborate his claim.
Yes.
That is not with us, Lordship. That is an issue.
That means either 73 or 75, he has worked. You don't dispute that.
That I do, because he has been absorbed
From there. So either
That
not
is
73, maybe 75, 76.
Whether it was
That date you are unable to ascertain.
that date,
But you have admitted he was there.
What I'm being instructed is 78.
78.
From where do we get this 78?
This is what my officer is instructing. So that he has to satisfy.
Worst case scenario, 91. Because after 5 years, he has been absorbed.
After 5 years.
So even if it is 91, half of it will make him eligible for grant of pensionary benefit. It is not that if half of his length is accumulated to 10 years, he will get any higher pension. Once he crosses 10 years, he will get the same pension.
Yeah, he has it.
Are there any stages of pension? Is that length any, does it have any relevance? Otherwise, irrelevant. 73, 78, the same, teacher remains the same. If the length will have an effect on the quantum of potentials, then we'll. He's taking 73. They are saying 78. No, they are not saying. She's just saying off the cuff. He has come and whispered in the ear and she's saying. They are not speaking. Yes, what? In some services.
Slabs are according to the length of service.
Oh, there is a difference.
There is.
So is it your case that from 78?
No, that's not their case. There is no such case before the tribunal.
That is
Nothing has been stated before the tribunal. Just a bald denial at page 79. Same is not admitted and hence the. Now see that way back. Then how much of that period is to be taken? Tribunal has accepted. Yes, adequate of the break. That will leave it to them to ascertain how many years. So therefore, even if you comply with the tribunal's order, you will still have an opportunity to examine how many years he has put in. It is only whether 31 has to be applied.
Yes, Lordship.
Now, therefore, we are again asking you why 31 has not to be applied.
Lordship, could I just, Lordship will give me, let me get the rule 31. Otherwise, I can't
All right.
satisfy your Lordship's Lord. Let me go through it.
Yes. When do you want?
Sometime next month.
Monday, as prayed by learned advocate. We are informed that if you're serving on the advocate, please serve by hand. Don't send it by post. Yes.
31.
All right. None appears on behalf of the writ petitioner. In before the next. So on the list, you saying that means what is and we don't have to see, they're not appearing there. But that's why I said second opportunity. Why, sir? Not today.
Thirty-three.
Not today. This has to be.
Thirty-four.
We are giving
like to start by affidavit by the respondent. So affidavit in reply be referred to be filed.
But did you submit the right proposition? The correct one has been filed. Earlier you had filed a wrong one. And copy has been served.
Like notice.
Your father, oh, by the petition. Hmm? Appearing. But if it when nobody is here, what is it? Whenever they appear, they will ask for time.
But it will reply.
None appears on behalf of the writ petition.
35.
My lord, I'm for the petitioner, my lord.
Not today. Not.
Great.
P6.
In item number 36, Your Lordship, I am for the petition. So on the last occasion, when Your Lordship was pleased to take this matter, where Your Lordship one point of law was framed by Your Lordship. That was Your Lordship the OBC certificate. Whether the OBC certificate can be accepted even after closing date of the notification, because the matter pertains, Your Lordship, that the petitioner appeared in the, Your Lordship, the examination undertaken by the, Your Lordship, fire departments, where, Your Lordship, the petitioner doesn't have the OBC certificate at the time of the, Your Lordship, the closing date of the notification. That was the issue, Your Lordship, where, Your Lordship, two judgment was relied upon by my senior.
Case is being shown on the screen. Why?
Take this matter, where Your Lordship kindly Your Lordship come to the last order you passed by Your Lordship, where the respondent was supposed to take instruction in respect of two judgment. On the earlier occasion, my learned senior relied upon two apex court judgment. One is Your Lordship Ram.
You have the judgments. Do you have the judgments?
Yeah.
Are you having copy of the judgments? Have a look. Tomorrow we'll take it up. Not today. The judgments are recorded in the last order of the court. You please
Item number 37, WPCT 18 of 25. Item number 37, WPCT 18 of 25. Item number 38, WPCT 19 of 25.
38, I'm for the petitioner, my lord. Appellant.
Krishna.
For the petitioner, appellant. But this is a matter, my lord, relating to grant of seniority. It is not clear. On the last occasion, my lord, your lordship was pleased to direct us to bring the 1987 circular, on the basis of which I was granted compulsion appointment. But page 72 is the appointment letter. The internal page 4 is the circular which says consolidated guidelines for making compulsion appointment. This is the only thing that I could have found out.
Page?
But internal page 4, the copy that I've handed over today, my lord.
It is not paginated.
Well, that is the only website copy that I have obtained, my lord. But subclause 2, my lord, 13, 1.3.5, subclause 2, letter dated such and such, the same date, my lord, containing latest consolidated guidelines for making compulsion appointment, and on the basis of which I have been granted the compulsion appointment.
1.3.5.
Yes, my lord.
Compassionate appointment of son, daughter, near relative. Reference.
Yes. Subclause 2, on the basis of which I have been granted appointment, which is at page 72 of my application. Page 74 is the contents. He joined as library assistant.
You are the widow.
Yes. The sum and substance is on 4th of September 1992, my husband expired. Thereafter, on 14/9/1992, I was granted compulsion appointment. But after serving 25 years in service, but my seniority has been disrupted. But from page 100, 120 onwards, the issue
Prior to this communication that you are trying to show us, by which communication you have been granted a different seniority, which you say has been disrupted?
Yes, page 120. Page 120, annexure P17. But
Yes.
here, the ministry asks them that if you have any complaint against anybody, you please write to us. Here, at page 121, if you 122, serial number 5. Here the problem starts.
You said that a seniority has been disrupted.
Yes, my lord, that is what I'm saying.
So where is that seniority which has now been disrupted? Which is the list showing you above this position?
Prior to this,
Yes.
my date of regular appointment was 1992.
We are not asking you that. You said your settled seniority has been disrupted.
Yes, that is.
So where
page
is the
121.
no? That 121 is the list by which you are aggrieved.
Yes.
Where is the list wherein you have been shown at a more senior place, which you say now has been disrupted?
If your lordship kindly takes up 109, starting page is 108. It's a communication dated 26th May 2017.
Page 108.
Yes, sir. This is the seniority list as on 31st of March 2017. Serial number 5.
This is not a seniority list.
In a similar OA list was published, my lord.
Sir, this is not a seniority list.
That, my lord, may I just submit?
And this is in this and the order that you just referred to are in quick succession. It's not as if for 20 years there was a settled thing which has been disrupted, as you said. This is also of 2017 and the other letter is also of 2017.
Now, my lord,
So there is nothing settled 25 years earlier.
No, what I'm trying to establish, my lord, that the grant of seniority has to be in accordance with the date of initial appointment. But in 1992, the grade was delinked, my lord.
So there is no settled seniority as you submitted. You are not able to show from any document that prior to 2017, at any point of time, you have been placed in a different seniority.
No, the seniority has been granted after 1995, considering my date of regularization. Now,
that is not seniority, sir. There are two things. One is a length of service and one is a seniority.
Yes, my lord. May I just place
So you said a settled seniority has been disrupted. So prior to 2017, we asked you whether any list was there wherein you have been shown at a more senior position.
That is the
Then what have you been? Then what has been shown in 2017? Now you are relying on a document which is not a seniority list. It is the draft seniority list which after objection has been finalized.
But if your lordship kindly
It
takes
is a very normal procedure
my
in
lord,
a gradation or seniority.
page 98, my lord, if your lordship kindly takes up. This is a list, my lord, which has been annexed by them in a different WPCT matter. My lord, wherein
98.
Yes, my lord. Page 98 of my application. This is a seniority list which has been which has been relied upon by them in a different WBCT. Serial number 55 is my name. They have considered my date of initial appointment for the list.
We don't know. There's no date. When this has been determined, who has determined this? Neither there is any signatory nor there is any date.
But it's an order. In compliance with judgment dated.
Sir, any order may be in compliance of any judgment. There has to be an authority who takes responsibility for issuing such
I
a.
did not deny also.
You have to satisfy us. This is a document which does not bear a date, which does not bear an issuing authority's nomenclature, and we should accept it.
But this was filed before the learned tribunal.
So if everything before the tribunal it was all right, then you would not be here.
Yes, ma'am.
So therefore we are asking you, how you can rely on a document like this? Neither a date of its issuance, we don't know when this was determined. Neither we know which authority will take responsibility for this. And you are claiming rights on the basis of this document. It says in compliance of some order passed in OA. We don't know. That OA is also not before us.
But this reference has been made here. We can just find it out whether it is true or not.
We don't know. We don't know. We are at a loss.
About page 130.
Whether a right can be determined on the basis of such a document.
My lord. Now, my lord, page 130, since the date has been changed without giving me an opportunity of hearing, my lord, I write to the ministry where the ministry writes back to me under RTI. Page 130 is the annexure, wherein, my lord, they have admitted that my date of appointment would be 1992.
Issuance of any order giving any particular date of appointment, will that confer a right on you, or the right will always hinge on the conditions and provisions contained in the rule in this regard?
But the rule says, my lord, the date of initial appointment.
The rule says the date of initial appointment, but that you have been appointed by giving a benefit of relaxation of qualification. It's not a regular appointment that it can be ipso facto applicable in all circumstances. You are not possessing the requisite qualification.
Lord, I have been given that, or I would say, my lord, I have been asked to possess that qualification after.
That also you have failed to do within the initial time fixed.
They have given me in 1993.
That you failed to do in the initial time fixed. Thereafter, extension was granted.
The university, may I say this, my lord, every university has that academic year, my lord. My lord, they issue that letter, my lord, page 75 is the annexure, my lord. They issued that letter in the month of October. But 1.5 years, I have possessed that qualification in accordance with their rules after being sanctioned by the authorities. My whole contention, my lord, small point, my lord, I have 3 years of service left.
No, actually, see, the question arising for consideration is that when you were not qualified to hold the post, can you get a seniority for the post? That is the only issue.
But then, my lord, I will rely on, my lord, one judgment of Supreme Court, wherein the Honorable Supreme Court was kind enough, my lord.
Because what is that period during which you were not qualified?
My lord, 1992 to 1995.
3 years. So whether you can get a seniority for this period or not.
My lord, in M. Chandra's case, my lord,
Huh?
my lord, may I just rely upon that? The judgment of the file as clip, my lord, clip. Kneel down.
But you have not given the rule in this regard.
My lord, we have annexed it, my lord. We have annexed it, my lord. The rules. Green color clip for us. But page 81 is the extract of the rules, and we have separately also handed over the rules itself. You can answer.
And what is this, a group?
This is group.
Which group post?
Let's see.
C.
Yes, Mullet. Let's clarify C or D, Mullet.
Yes, in page 81, this 16A is there. 16A, page 81.
My lord.
That is the appointment made on ground of compassion. Okay. So what is 16B? It's not here.
My lord.
So that is to be clarified, that 16A.
My lord, we had separately, my lord, handed over the scheme for compassion appointment.
No, you see, as per the rule, seniority.
My lord.
Right, not rule 16. 16A is there. So where is 16B? They should have the qualification. Where is 16B? This mentioned. But to have the qualification. What is B?
Do you have the full scheme?
This is a determination of seniority art of compassion.
This is not the full scheme. You have just annexed one page of the
My lord,
scheme.
my lord, that is my fault, my lord. My lord, if your lordship kindly takes up the notification of 1992, my lord, which I have just handed over 2 pages.
No, this is scheme.
Paragraph 2 will be clear, my lord.
Yes.
No, this is scheme. Give us the full scheme. We must see this entire scheme.
But this is possibly, my lord, accuses.
We are asking you to show us this entire scheme. You are not showing us. Why should we rely on one page of the scheme?
Circular all to be taken.
Copy sorry, but I just have one copy of this.
No, give us 2 copies. No, sorry. You have the entire OM of 9th October 98.
October 98.
You have the entire thing.
Yes, madam.
Give us 2 copies.
Then kindly takes up tomorrow.
Yes, not today. Correct. That has to be seen.
I hand over the two judgments, my lord.
Yes.
Judgment. But tomorrow I shall hand over the notification. 98.
File number 39, WBCD 20 of 25.
No, order can. সব কিছু বিল হবে নাকি?
Well, the petitioner before the applicant before the learned tribunal was a casual employee of the Duradorshan matter. And who the temporary status matter. Who was engaged in 7th. Last two occasions, the learned advocate of the respondent was happy at matter.
Last two or last only once it has been.
Thereafter matter was on 2 weeks ago matter was taken up, and my lord, your lordship was directed me to distinguish the judgment of real 3 judges bench, and thereafter the matter was adjourned. That order was not got in the website also, my lord.
It's not here.
Not possible to decide.
You are for the Union of India.
Yes, ma'am.
You are for the Union of India.
I'm for the Union. And out of my lord the 24 years of service, he enjoyed my lord the 15 years my lord temporary status. And my lord, he retired in the year of on.
Somebody is appearing online.
Lordship, I am on record in this matter, Lordship. Due to viral fever, I am appearing through virtual.
You are for the respondent.
No, Lordship, I am for the petitioner. I am Sir Junior. I am on record in this matter. Joita Dhar.
Oh my lord, he is my lord the advocate on record. He is junior to me. And my lord, he retired from service on 13th of November 2010. And my lord, after his retirement, the policy was enforced in the year of 2013 regarding the regulation of those employees, my lord. And my lord, thereafter, the petitioner filed original application before the tribunal after his retirement. And in the first way application, the Honorable Tribunal directed to consider his case regarding the regulation and the pensionary benefit. And that was considered and rejected. Thereafter, my lord, he filed a second application. And your lordship, kindly see the 2-3 paragraphs from the impugned order, my lord.
In absence of the other side, how we can proceed?
Completely, my lord, the two question of my lord, completely that is based on my argument on 2 points, my lord.
Yes. Should you make your submission in his absence?
I am also not, my lord, to argue in absence. It is I do also
He will, unless he hears you, how he can respond? So Can we have it tomorrow? Not today.
So, my lord, kindly pass one line order.
None appears on behalf of the respondents. Before that, the learned advocate for the petition.